All right, class, this is the lecture for the procedural due process piece for Con Law 2. And as I mentioned to you guys in class, procedural due process is really kind of a simple concept that is really kind of easy to follow along. But I'm going to break it down a little bit for you here so that you can understand it and be prepared to write for it should you see it in the context of the bar exam and or a final exam. So the procedure due process clause is a part of the 14th Amendment. As you well know already, the 14th Amendment prohibits states from taking a person's life, liberty, or property without due process of law. Procedural due process simply refers to the procedures, right, that the government must follow before or when it deprives a person of that life, liberty, or property. So there's a framework like all of the other constitutional law concepts that we've studied this semester. There's also a framework for addressing a procedural due process question. And so take note of this and make sure that if you should come across a question that the issue that you spot is a procedure due process question, that you would approach it in this way. First, you need to ask yourself, one, has there been a deprivation? Has something, a thing, or a person been deprived of a thing by the government? A sub-issue in answering that question is, does the individual have a vested right or interest in the thing that they are allegedly being deprived of? And so, again, the first question is, has there been a deprivation? The second question is the thing that the person has been deprived of life, liberty, or property? That dovetails directly with the language of the 14th Amendment. And so has the person been deprived of their life, their liberty, or their property? The third question is the deprivation without due process, meaning has that person received the appropriate notice and the appropriate opportunity to be heard to redress whatever the thing is that they're being deprived of. And so in answering the question of has the deprivation been without due process and considering notice, the notice must be adequate. In looking at notice, you have to ask yourself what type of notice is required. Is notice required prior to the person being deprived of that right, or is it required after the person is deprived of that right? In considering an opportunity to be heard, the opportunity for the hearing must be meaningful and by a fair and impartial decision maker. And we'll get into some specifics based on case review to what that actually means. So that's your three-part breakdown. Has there been a deprivation? Is the thing the person is deprived of life, liberty, or property? And is the deprivation without due process? Again, and when asking yourself what processes do, you will know both a notice and an opportunity to be heard, depending upon the kind of deprivation that's involved. And we'll get into the specifics of that a little bit later. So, from a case standpoint, when asking yourself what is a deprivation, one of the questions that may come up is, how do I know if I'm being deprived of a right, or has the government deprived of me of a particular right that I'm entitled to? And the case of Daniels and Williams answers that question. And the facts there were real simple. A petitioner sued under Section 1983 of the federal civil rights statute for injuries that he sustained while he was an inmate in Richmond City Jail. Apparently, the inmate claimed that a deputy had left a pillow on the stairs and that he slipped and fell on the stairway because of the pillow. So the question in that case was whether negligence by a government official that results in injury to someone else implicates the due process clause such that there is a constitutional violation. And the court held in that case, no, it doesn't. And the key takeaway from there is that the guarantee of due process should be applied to deliberate decisions of the government to deprive a person of life, liberty, or property. So these, whenever a government deprives a person of life, liberty, or property, then that deprivation has to be intentional. So the court determined that the provision, the due process, procedural due process provision, was designed to protect against arbitrary exercises or abuses by government officials, and to supplant what's known as traditional tort law. So there are other areas of remedy for the issue, the challenge, if you will, that the inmate had in the Daniels case to address that. But the due process clause of the 14th Amendment was not one. And so the court determined that he had not been deprived of life, liberty, or property. When does a deprivation occur? That's also an important part of that determination of what is a deprivation, is when does a deprivation occur? And so one key question that has come up in that context is whether a deprivation occurs at the hands of private individuals. And so oftentimes, keeping in mind when we are analyzing our constitutional questions, there has to be some action of the state, right? The government has to do that. And so the question arose in the DeShaney v. Winnebago County case as to whether or not a deprivation had occurred by the state. And in that case, long facts, but essentially a little boy had been abused by one of his parents, and his parents, well, actually his father and the father's girlfriend. And there had been multiple occasions where representatives from the Department of Social Services had checked in on the child over the years, until finally, when the child was 4 years old, the child had been beaten so bad that he was in a life-threatening coma that resulted in severe brain injury and traumatic injuries that had been inflicted on the child over a period of time, such that the child was confined to an institution for profoundly retarded individuals for the rest of his life. The father was tried and convicted of child abuse, and the child's mother sued the Department of Social Services. And so the question there was whether the failure of social services to remove the child from the home after receiving reports of the father's abuse over a period of time deprived the child of his liberty in violation of the due process clause of the 14th Amendment. And the court determined that it hadn't. And in an interesting opinion, the court said that the state's failure to protect an individual against private violence simply is not contemplated in the due process clause of the Constitution. And the court specifically said, nothing in the language of the due process clause requires a state to protect the life, liberty, or property of its citizens against invasion by private actors. This clause was designed to protect citizens from abuse of power by the government or acts of oppression by the government. And so keep that in mind if you see a question arise of a potential due process, procedural due process issue, and it's a private actor. The due process clause was not designed to protect citizens from each other, but rather to protect citizens from abuse of power by the government and or acts of oppression by the government. A natural question as it relates to the DeShaney case and the case that we're going to discuss next is it a deprivation of life, liberty, or property? And so you've answered the question, is the person being deprived of something, right, of a thing? And is that thing, the next question is that thing that they're being deprived of a deprivation of life, liberty, or property? In the case of Goldberg v. Kelly, was a key case in recognizing privileges as requiring due process. And when I say privileges here, I mean privileges are entitlements to assistance by the state government. And so the issue in Goldberg was whether a state that terminates public assistance payments to a particular recipient without affording that recipient an opportunity for an evidentiary hearing prior to the termination of that right denies the recipient procedural due process in violation of the 14th Amendment. And the court determined, yes, that they do. When welfare is discontinued, only a pre-termination evidentiary hearing provides the recipient with procedural due process. And so in Goldberg, the court determined, look, you can't just take away a person's rights without giving that person an opportunity to be heard about that deprivation of that right. For recipients, welfare provides the means to obtain essentials of life, such as food, clothing, housing, medical care, and the like. And terminating these rights or termination of these rights pending resolution of entitlement may deprive an individual or an eligible individual of the very means by which he has to live while he waits. And so, again, a person just cannot have those rights terminated without first having an opportunity to be heard regarding the termination of those rights. And so Goldberg fashions out that key point for us there. Goldberg also asks, well, what process, or also rather answers the question, well, what processes do? And the court noted that the person does not have to have a judicial trial or a quasi-judicial trial, but it does need to be at a meaningful time and in a meaningful manner. And we're going to go over some key points that answer what processes do in a later case, but Goldberg took the first stab at answering that question. Goldberg also suggested that the recipient must also have timely and adequate notice detailing the reasons for the proposed termination and an effective opportunity to defend by confronting any adverse witnesses and by presenting his own arguments and evidence orally. So that's the first stab. Goldberg gives the first stab at what processes do when you are considering the deprivation of life, liberty, or property. Well, what is a deprivation of property? And so the recent case of, I'm sorry, not the recent case, I got it confused with another one. The case of, rather, the Board of Regents v. Roth answered that question, what is a deprivation of property? In that case, the defendant, Mr. Roth, was hired at Wisconsin State University under a one-year contract. He didn't have tenure, and he could only acquire tenure after 4 consecutive years of teaching at the university. He received notice in February of 1969 that the contract that he was operating under would not be renewed, and he sued in federal court, alleging that the decision not to rehire him infringed on his 14th Amendment rights. And so the question was whether the university or whether a university that does not renew a one-year contract of an employee hired for only 1 year violates that person's due process rights under the 14th Amendment. And the court held that it does not. And critically, the court determined in order to have a protected property interest, a person clearly must first have more than an abstract need or desire for it. He must have more than a unilateral expectation of it. He must have a legitimate claim of entitlement to it. And so the court essentially determined that the professor wasn't entitled to any pre-deprivation hearing because there was no interest to which he was entitled. He wasn't entitled to any interest in working under this contract, this one-year contract for his job. The case reiterates that liberty and property interests encompass privileges and property other than traditional interests, including more than real estate, money, and the like. And so in the case, the court notes that, and they list several recognized liberty interests, such as the right to contract, the right to engage in common occupations of life, the right to acquire useful knowledge to marry, establish a home, etc., and a person's right to enjoy those privileges as long being recognized as essential to the orderly pursuit of happiness by free men. So take a look at the Board of Regents v. Roth case for that list of some of those long recognized rights. But again, the court determined that that his the university's decision to not renew his contract was not a deprivation of any property right that he may have held. Important in that case was two methods that the court determined and that they used in deciding if there is a liberty or property interest. The first method is look at the importance of the interest at stake. Is the interest at stake so important that it could be determined to be a liberty interest or a property interest? The second method that the court used is to determine if something in the state law created an expectation in the individual that the right of interest would continue. And the most recent approach used was that method that the court used in Board of Regents v. Roth. And so for the answer to the determination of what is a deprivation of property, the Board of Regents v. Roth is the case for you to to note there. Let's see. So what procedures are required, right? Well, before we answer that, let's back up. And so, again, first question in the procedure due process breakdown: has there been a deprivation? Second question: is the person deprived of life, liberty, or property? And the third question: is the deprivation without due process? And so, it's that question that we'll get to now in asking what procedures are required, right? What type of due process is required if we're talking about a particular sort of deprivation? And there are basic safeguards that are included in answering that question. First, there must be adequate notice of the charges or the issue. So in other words, if a person is going to be deprived of a right, they have to be notified as to what they're being deprived of. What is it that the government is attempting to take away from them? That needs to be clearly articulated by the government, and they have to be provided adequate notice of that deprivation that is to come. The second piece is they have to have an opportunity for a meaningful hearing. And like we talked about in the earlier case above here, in Goldberg, I believe it was, they have to have a meaningful time to be heard, and they have to have a meaningful manner in which to be heard. And so it can't just be a kangaroo court or a sham process for that person to speak to the thing that they're being deprived of, but that it has to be meaningful, both in time and manner. And the determination, the final piece, the determination must be made by an impartial decision maker. And that, in other words, an impartial decision maker could be a judge or a hearing officer or the like. However, depending on the deprivation, and I should have said this earlier, when you're talking about the type of adequate notice, depending upon the deprivation, the notice that's required may be different. It may be that they're required to be notified by personal service, like in the instance of a lawsuit or the like. It may be that they're required to be provided notice by mail, like you may have in certain types of hearings for employment rights or appealing of an employment termination or things of that nature. It may be that notice is posted on the door, right, in the case of an eviction. And so depending on the deprivation notice, the notice that may be required differs. When you're talking about the meaningful hearing as well, the kind of hearing varies. And we talked a little bit about this earlier. It may be a pre-deprivation hearing or a post-deprivation hearing, depending upon what the interest is that's being involved. And finally, when talking about the impartial decision maker, like we just stated, that could be made by an arbitrator, a judge, a hearing officer, or the like. So with that in mind, regarding what procedures are required, make note of the Matthews v. Eldridge case. This is an important case regarding um, the procedure to be used, or I'm sorry, when rather the procedure to be used is required, and it's akin to the Goldberg case, and it even references the Goldberg case. So make sure you note that in Eldridge, or in Matthews rather, Eldridge had began receiving Social Security disability benefits in 1968. In 1972, the state agency that administers the Social Security benefits sent him a questionnaire regarding his continued disability, and asking about things like his medical sources, including physicians who he had received treatment from, and the like. And so after Eldridge completed the questionnaire and sent it back in to the state agency, then obtained reports from the physicians and the other healthcare providers that he had identified in his questionnaire answers. And after reviewing this medical documentation, made the determination and sent Eldridge notice that they had tentatively determined that his disability ceased in May of 1972. And so they gave him an opportunity to respond and submit additional information, however, pertaining to his condition. And Eldridge did just that. He wrote a written response, and he disputed their characterization of his condition and said that the information already provided evidence of his continued disability. So that was his reply, and after they received his reply, the agency sent him a final determination that his eligibility had ceased in May of 1972. And in July of 1972, the Federal Social Security Administration accepted this determination from this state agency and sent Eldridge notice that his benefits would stop after that month, or after July of 1972. They also notified him that he could seek reconsideration within the next 6 months. So after, after receiving this notification, Eldridge decides to sue. So the question is whether the Due Process Clause of the Fifth Amendment requires the recipient of Social Security disability payments to be afforded an opportunity for an evidentiary hearing prior to determination of those benefits. And the court determined that no, an evidentiary hearing is not required prior to determination of disability benefits, and that the present administrative procedures fully comported with due process. So why is that? When you think about this in terms of the court's decision in Goldberg, well, the court found here that the deprivation was less than that in Goldberg, where they determined that a predetermination hearing was required. And the court noted that the disabled worker has the potential for other sources of temporary income, such as welfare, family support from others, workers in the household, etc. Thus, something less than an evidentiary hearing is sufficient prior to administrative action, which is different from the case of Goldberg, where Goldberg, in that case, forfeited the welfare payments, or the temporary assistance payments, and they, without any sort of notice whatsoever, or without rather a prior pre-termination evidentiary hearing. So, in arriving at its conclusion, the court, back to Matthews again, noted that the present procedure, where the decision to terminate was based on medical information from the recipient's medical records and the physician's statements, and the fact that the recipient was given access to information, all of that was accurate. So a key takeaway from Matthews v. Eldridge is the factors that the court considers when deciding what process is required by the due process clause. And so the court considered three questions in arriving at that answer. First, the court asked, what is the private interest that will be affected by the official action, right? What interest, be that life, liberty, or property, is being affected by the official action? The second question that the court considered was, what is the risk of an erroneous deprivation, taking this deprivation away improperly through the procedures that are being used? And what is the probable value of an additional or substitute procedural safeguards to prevent that? So in other words, what is the risk that is being run by taking away this right or this thing, this life, liberty, or property in an erroneous way? And what is the probable value if we had substitute procedures in place to execute this deprivation? The third factor that the court considers is what's the public interest, including what's the function involved and what's the fiscal and administrative burdens that substitute procedural safeguards would entail were they to be implemented. And so these were the three takeaways that the court considered when deciding what process was required by the Due Process Clause of the 14th Amendment. And so as a quick wrap up, in a procedural due process question, quick analysis breakdown. Has there been a deprivation? In answering that question, you're also answering, or you're looking at the sub issue, does the individual have a vested interest or right in the thing that they're being deprived of? The second question, is the thing the person being deprived of life, liberty, or property? And remember that language dovetails exactly with the language of the Due Process Clause. And finally, is the deprivation without due process? Meaning, does the person have, or has the person received notice, right? And that adequate notice, whether it's pre-deprivation of the right or post-deprivation of the right. And have they received an opportunity to be heard? Have they received meaningful a meaningful opportunity to be heard by a fair and impartial decision maker? So that's a quick overview of procedural due process. I hope this has helped. If you have any questions, feel free to email me and we will get right to them. Thanks, guys.